Good morning. I want to welcome you to our first Golden Years Wellness and Awareness Conference. You're being sponsored by the Hardin County Extension and Homeowners. This whole event. Can you hear me better now? Yes. I'm sort of a little bit nervous. Okay. I'm so proud that we've got the turnout that we've got. I really appreciate everybody for coming. I would like you all to look around and see all the exits signs so you know what to do if anything were to happen. We have bathrooms down the very end. It's almost, you'll see the doors going out on this end. And then we have bathrooms in the hallway on this side. And then there's some bathrooms out front in the lobby. Okay. Our first speakers are Cynthia Grimmon, attorney at law. We got Ben Humphreys, attorney at law. And we got Gregory Schreck, and he's our CPA. And so they're going to be talking this morning, and then we got two this afternoon. I'm sorry, I keep on doing something different here. They're probably going to try to give you all some breaks in between their times. We will have lunch at 12 o'clock. The tables will be set in the hallway, and there will be ham on the left, and we'll have chicken on the right. And so you all should have got a ticket for ham or for chicken. Okay, and you also should have got a ticket for your door prizes. And we've got some really, really nice door prizes. So what you need to do is if you win the door prize, do not throw your ticket away. Because at the very end, we're going to put all the tickets back together and we're going to have one big door prize. And it's a pretty good door prize. I would like to tell you all how all of this came about. My mother, Mavis Hart, she passed away last October, and she was in the hospital for about a month before that. Well, the wreck was June the 16th. And so during that time, she was in the hospital for a little while. She was in a nursing home. And there was a lot of questions that was raised during that time. Questions I had no idea about. Powers of attorney, medical powers of attorney, just wills, trust. There was just a lot of different things and that I learned about that I actually didn't know before. And I had been I'd worked in a bank for a little while, and whenever I worked at a bank, a power of attorney was 3 pages long. Well, they're not 3 pages long anymore. So I really wanted everybody that I could to get educated as to what they need now, right now, before time that it's definitely needed. So I just want to welcome you all, and we have a panel, and do you guys want to say something? And so we will start now.
Hello, my name is Ben Humphreys, and I work with Kentucky Estate Planning Law Center. My law partner is Lewis Graham, or L.H. Graham, as some of you all may know him. He's from White Mills, Kentucky, and he's not with us today, but I'm very thankful for being here, and thank you to Regina for putting all this on, and thank you all for everybody for being here. Cynthia.
Good morning. Thank you all for being here. And just to echo what Ben said, we are so excited that so many of you have come out because you want to educate yourselves on what you need for yourselves, for your loved ones, for your aging parents. And we are looking forward to sharing with you, and we look forward to your questions as well. So if you have questions, we are going to have a question and answer time at the end. But certainly take the time to write those down if you can. If you feel like you just have a burning question, please feel free to interrupt us and get that answered, okay?
Welcome, and I'm Gregory Schreck with Result Point Financial here in town, financial planning, and also a CPA. We will try and have a break around 11 a.m. Depending on the presentations and how they flow. So that way you'll know kind of when we'll have our first stop, but definitely somewhere around then to make sure you're not bursting at the seams as we go along. So I think we're going to get started now.
Sounds good. So we're going to try to make 3 promises to you. Time's going to fly. You're going to learn a lot and hopefully have a little fun. And the only thing we ask of you all is that you all stay awake. That's it. So no, but we're going to be talking about a lot of difficult things, a lot of difficult situations, and we're going to try to make sure that it's done in a way that we can all learn but enjoy our time, even though these are very serious topics. And so we're going to try to do this in a way we're all sharing and talking. Just a little bit about myself. The reason I do estate planning is when I was about 8 years old, my grandmother got Alzheimer's, and she and my grandfather got sick. He had a heart issue, and they ended up putting a pacemaker in with him, and then he died shortly thereafter. And my grandmother went into the nursing home for 12 years. And I remember the day she went in, and we were there the day she died. And 12 years is a really, really long time to be in a nursing home. And during that time, the 12 years, my grandparents lost everything they owned. Okay, and so not only did they lose all of their assets, but their family got in a big fight. My aunts and uncles and my cousins and all those people, we went from being a family that saw each other every Sunday after church, eating together, Christmas together, all those things, to we went from that family to a family that didn't see each other for 30 years. And so what we try to do, what Cynthia does and what I and Greg try to do is make sure your families don't go through that same experience of losing your family and your assets because you didn't plan, right? Okay. All right, very good. Anything else to add, Cynthia? All right. Go ahead. So this is the first slide, and we're going to go through this together, but we did a workshop up on the Wesley Hilltop, and there was a bunch of older people there, and one lady raised her hand and she said, "Do I need an estate plan? All I've got is a house, a checking account, and a car. I'm not rich. Why would anybody with those type of assets need an estate plan?" And so what we try to tell everybody is that estate planning, you don't have to be rich, okay? And estate planning just simply means that you've thought about your stuff and where you want it to go to during your lifetime and then after you pass away. Just putting a plan in place. So you don't have to be rich at all to have an estate plan. And so we just like to point that out. So estate planning comes down to 3 issues. Who's in control of your stuff? Who gets to benefit from your stuff and when? You all may think that that's too basic. I just went to a law seminar last week. This is what they told all of us lawyers, these 3 things. That's what estate planning comes down to. And so this is actually high-level stuff. You have to understand these 3 basic questions for your assets and for yourself during your time. Anything to add there, Cynthia?
I would just add that a lot of people are still thinking, well, I still don't have that much stuff. If you are here, you have a body. So you do in your estate plan, something that Ben's going to really talk about is how important it is that somebody have the ability to make decisions for you as a human being. So whether you're concerned about, and sometimes we'll hear, well, I don't really care what happens to my stuff. You probably do care about what happens to yourself as a person.
Okay. Go to the next slide there. All right, so there's 3 phases of life, okay? And you need to be planning for all 3 phases of life, all right? And the reason we say that is so that when you're alive and well, you know, who needs an estate plan when you're alive and well? Raise your hand. The answer is nobody, right? You don't need an estate plan, right? But the thing is that all of us may have an accident or illness at some point in our lifetime, and then obviously all of us pass away at some point in the future. So those 3 phases of life, and so what we like to tell people is when you're alive and well, you don't really have to have documents, but the problem is you don't know when you're going to go from alive and well to accident or illness or to death. And I always tell people that my grandfather died, my mother's dad died in a heart attack in his sleep at the age of 60. My Aunt Jean, my mom's sister, died of a brain aneurysm at the age of 50. Neither one of them were on any sort of medicine or anything, no real issues. My cousin Billy Joe, he was an ER doctor down in Alabama, Birmingham, Alabama. A tractor trailer lost its brakes and T-boned him at an intersection at a light. He ran through a red light and he died at the age of 40. My cousin Dow Roby, he was helping out his English teacher dig out a basement. He was 18 years old. The house collapsed and fell on my cousin Dow at the age of 18. And so the reason we'd like to point this out is, who here knows exactly when your day is going to come? Go ahead and raise your hands. If so, go ahead and buy your lottery tickets and all those other things, because you must be clairvoyant, right? But none of us know when we're going to go from alive and well to needing an estate plan. And so that's the main thing here. But also we like to point out that when you have an accident or illness, that is when you're going to need a power of attorney. Okay? So when you're alive and well, you can sign your documents. When you have the accident or illness, that's when you need a power of attorney. We like to give people a business power of attorney, a medical power of attorney, as well as a living will. All three documents for every person that does an estate plan. And then we also make sure that that person has a will or trust. And that is what we call a comprehensive estate plan. Just having a power of attorney is not a comprehensive estate plan. Just having a will is not a comprehensive estate plan. And hopefully you all see that if you just have a will, then who's going to sign your documents for you if you're alive but you can't sign? Who can sign? Anybody? No, you don't have one if you just have a will, right? And so if you're in the hospital and you can't create a power of attorney, it's too late, right? And so you got to have this stuff in place ahead of time. Anything to add there, Cynthia?
No, but I have a question. Probably some people are thinking, well, what about my spouse? Can't my spouse just sign for me?
That's a great question. I just met with a couple before I came over here. They didn't understand the need for that power of attorney. And so I'm going to pass the buck to Greg. Greg, let's say that I get in a car wreck. I'm in Hardin Memorial Hospital, or Baptist Health, Hardin now they call it. And my wife calls you and says, Ben is in the hospital. He's been in a car wreck. He's knocked out. I need to clean out his IRA because I want to go take off down to Bermuda with all Ben's money. All right, Greg, can she do it?
No.
Very good.
Simple answer.
Why is that?
She is not on that IRA as an owner. Now, if she had the power of attorney and she could bring that in, then definitely at that point, she is enabled to control some of those funds and use some of that money to help with medical care. But unfortunately, unless that's not the case, legally she doesn't have access to those funds.
So even though we're married, she can't access the funds because her name's not on the account. Is that correct?
That's correct.
Yeah.
Yes.
Very good. All right. So right now, I generally like to tell the story of Terry Schiavo. Does anybody here know the story of Terry Schiavo? Yep. Terry Schiavo was a lady down in Florida. She was married and she had a mom and dad. And Terry Schiavo got really sick. She was like in her 40s or 50s, about my age and about the age of us up here. And she got really sick and went into a long-term care nursing home, okay? And there was a question about, was this the end for Terry, okay? Her husband thought it was the end. He thought that this was the end, that he needed to go ahead and let her go, to let her pass away, remove medical treatment. Terry's parents did not agree. Terry's parents wanted to keep their daughter alive, okay? So all of us think, oh, my family will work it out in the end, in the hospital. Sure enough, everybody will get along. I don't need to write down what I want to happen because my family's different. We all know what I want because I've talked to them about it. I bet Terry Schiavo said the same thing. But the problem is just talking about it with your family doesn't fix the problem if your spouse and your parents disagree on what treatment should be for you. Does everybody understand that? If you have a disagreement within the family, then just a word of mouth verbal agreement's not enough. So what happens if you don't have a plan? Does anybody know what happens to your family when you don't have a good estate plan? Huh? Murder? No, you hire lawyers like me and Cynthia. Your family ends up paying all of your hard-earned money for lawyers to go litigate these issues in court. And in fact, that's what happened with Terry Schiavo's family. They ended up in court, and the case went all the way to the United States Supreme Court. And when I was in law school, that case was going on, and the President of the United States, George Bush, actually filed a brief in that case. So think about that. Terry Schiavo was just a normal person like you and me, like us up here, just normal, everyday person. And here we have the President of the United States filing a legal brief in her case simply because Terry Schiavo didn't have a living will. Who here thinks Terry Schiavo's estate plan worked? Anybody? No, it didn't work. Anything to add on that, Cynthia? So that's why we always say you got to get these powers of attorney, living wills in place, because you could end up like Terry Schiavo. Anything to add to that, Greg? Nope. So on powers of attorney, we always recommend you have a primary person appointed and also a backup in the same document. I've seen a lot of powers of attorney done in surrounding counties, and they'll appoint one son as a power of attorney in one document and a daughter in another document. They'll have two powers of attorney. You don't want that. That's bad, in my opinion, bad practice. You want everybody to be working off the same sheet of music. Who's in charge? Who's the backup? And also people say, well, I don't know if I could trust my backup. And the reason your powers of attorney need to be updated. And the reason they need to be updated is that they have come to a uniform power of attorney across America. Okay? They've come up with laws about what does a power of attorney need to look like. And the reason they did that is because there was a lot of powers of attorney that were actually taking assets from people, misusing the power of attorney. And so what the new power of attorney document does, it lays out on the back of the power of attorney what your power of attorney cannot do. They cannot steal your money. They cannot act against your interest. They cannot undo your estate plan. They can't do any of those things. And when we do your power of attorney, we actually make the person you've appointed sign that document saying, I promise not to take your money. And the reason that is that we don't want you to just give somebody a blank check to your funds, okay? And so with the new power of attorney forms, you've got more protections. And if you have a power of attorney that doesn't have those protections, in my opinion, you need that document updated, okay? Anything to add on that, Cynthia? I must be doing okay. They don't have their 2 cents. Anything to add to that, Greg?
Also, though, it is helpful when he talked about the son and the daughter to have backup power of attorneys. So you don't just need a son or a daughter.
Yeah. All right. So make sure you've got powers of attorney in place. Make sure you've got a backup. Make sure your form is updated. If your power of attorney is 1 page or 2 pages or 3 pages, it's out of date. I hate to tell you, even if it was done this year or last year, there's a lot of local practitioners in Hardin County and outside Hardin County that are still using the old forms, and the old forms will not work. The banks will reject them, and also you've not given yourself enough protection. And I presume you use a new form as well, Cynthia. So, all right. So who here can tell me when powers of attorney end? When do they terminate or end? Does anybody know? That's right. You'd be surprised how many sons and daughters come in the office and say, Mom or Dad has died, I'm the power of attorney, I'm just going to keep paying the bills like I always did. We have to tell them, no, your power of attorney is ended. At this time, you cannot act as the power of attorney anymore. And so therefore, that's when the will or the trust would kick in. And so hopefully you see now why you need a full comprehensive plan, because while you're alive, you need the powers of attorney. And then after you die, your power of attorney doesn't work. And so you need a will. And so just a will is not enough, and just powers of attorney are not enough. Okay? Does everybody get the idea of a comprehensive estate plan? And notice that both Cynthia and I and Greg, none of us said you had to be a millionaire to have an estate plan. You just have to have stuff. Does anybody here not have stuff? No. Everybody's got stuff, so you need a plan. All right. All right. Go ahead. Next slide there, Greg. All right, do I need a will or a trust? How many times do you get that question, Cynthia, I bet?
Pretty much every consultation there.
That's right. And so we always tell people, you're going to need what you need in your plan. Just because your neighbor got a will or your neighbor got a trust, that doesn't mean that you need those things. Everybody's different. Everybody has different assets. Everybody has different family members. Everybody's got different problems. I'd like to trade my problems with Greg. I don't know about you, Greg. No, I'm kidding. But everybody's different. And so just understand that it's not just cookie cutter, okay? You need a specific plan for you and your family. Go to the next slide. All right, we're going to give you all a law degree when you end today. Greg's going to pass that out, but this is the law that you're going to need to know. I'm kidding. And so we're going to need to go over types of legal ownership, what a will is, what probate is, what a trust is, and how it works, how legal ownership trumps your estate plan, whether you have a will, a trust, both, or neither. Go to the next slide. All right, Cynthia, you want to tackle this slide? It's pretty good.
Types of legal ownership. This gets really confusing to a lot of people whenever they come in and they see something in their will and they think it's absolutely going to pass through that will because that's what the will says. But The will is kind of like your crumb tray. It catches everything that didn't already get passed out in other ways. So you have different types of legal ownership. You can have joint ownership. If you and, say, your spouse or you and a child co-own something together with a legal right of survivorship, then they're going to continue to own that after you die. If you have a beneficiary designated on like an IRA or a 401k, even some bank accounts, life insurance policies, annuities, then the beneficiary that you have named on that plan, they are going to receive that outright outside of your will, regardless of whether your will addresses that. Payable on death accounts, transfer on death accounts, those are typically done either through a bank or some kind of insurance policy or qualified retirement account in trust for someone, or it could be in your name alone, and that's what actually ends up passing through your will, something that the leftover. So that's why I call it your crumb tray. So it's whatever is left in your name. That is what has to go through your probate.
Yeah, well done, Cynthia. So Greg, we're going to give Greg a test. We're going to test Greg's knowledge here. Mr. Schreck up here. All right, Mr. Schreck, my will leaves everything to my spouse, but I own my Ford Ranger pickup truck with my father jointly and in survivorship. When I die, who's going to get the Ford Ranger pickup truck, Greg?
Because it's joint ownership with your father?
Yep.
Okay, then the father assumes ownership of that upon death. So even though you are leaving everything to your spouse, because you own that jointly, the joint person will inherit that asset.
All right, so that's an important point. This is another important point we get all the time. All right, let's say I've got 5 kids, and I really do have 5 kids. So if anybody wants one, we're going to give one away at the raffle afterwards. But let's say I've got 5 kids, and I only put my favorite child on there, on a joint checking account. Everybody has a favorite child. Come on, admit it. Everybody's got one. No, I'm kidding. So let's say, Greg, that I put my favorite child as a co-owner on a joint checking account, but my will leaves everything in equal shares because I love all of my children equally. Who's going to get that joint checking account, Greg?
I think you just cut out the other 4.
No. That's right. So hopefully you all understand that how you own things can trump what your legal documents say, okay? And so the reason we really hammer this home is I can't count the number of times I've had people say, my lawyer told me that my will was my last wishes and it trumps everything and it controls everything. And we have to tell them that is a legal myth that you have just told back to us, and it's not true, okay? How you own things will trump what your estate planning documents say. And it's a very, very important distinction because I can also not count on how many times on my hands, how many people have named one child as a joint owner on an asset, and that one child has not shared those assets with the other family members, and those other family members felt cut out. Does everybody understand how that happens? And you want to avoid that as part of your estate plan, okay? Yeah.
Okay, so one of the takeaways to this is you want to go back and look at all your bank accounts that you have with the banks and understand what ownership those have, whether they're joint, single. If you have any IRAs, you want to look at the beneficiaries, okay? So probably the default is your spouse at 100% unless you've done something different where you've already have the children. But you can add contingents. So you may have your spouse as 100% beneficiary on an IRA, and then you can name your children beyond that. But those control those assets. So when you get back, you want to review your investment accounts, your checking accounts, IRAs, that type of thing, to understand how those pass, because that ownership will trump that will trump the will.
So the big thing here, I'm going to roll through the assets here. So if you have real estate, so if you've got a house or a farm, you need to get your deed out and look for the words joint with survivorship. So if you're married and you want to own something with your spouse, you need to look at your deed and make sure it says joint with survivorship. And you may say, oh, Ben, I got this done at the title company. They know what they're doing. Just so you know, I had a client come in, his wife had died, and their deed was not done properly. It did not say the words joint with survivorship. And so so I had to tell the man, I'm sorry, sir, but we're going to have to go to court and get the half of the house that you've already bought and paid for one time, that half is going to go through the probate court. And guess what? His wife died without a will, which now meant that a fourth of his house now went to children that he had not seen in over 5 years. So just understand that. A lack of a plan, a lack of just getting your documents out and reading them now had not only caused him to go to court, but now he was going to have to locate this family and go through this very difficult dynamic of sorting all this out just because he didn't get all this stuff out and have a plan. Okay, that's how important this is. Do you have a question? If anybody has a question, just raise their hand. So on your deeds, joint with survivorship, vehicles, cars, boats, trucks, motorcycles, trailers, all those things have a separate legal title that you have. Make sure that if you want them joint, it needs to say the word or. So Ben or Cynthia, Ben or Greg, okay? If it says the words Ben and Greg, I own half, he owns half. It's not joint survivorship. It will not pass to him when I die. Everybody understand? If me and my wife own a car and only I am on the car, if my name is only on the car title and I die, she's going to have to go to court on the car title. Does everybody understand that? So get out your car titles. Make sure you're both on the car titles, okay? Maybe you put a child's name on there so it avoids probate court. All those things are possibilities. Okay, so a lot of people also say, what about my checking accounts? How do I know if my checking accounts are joint? Unfortunately, you're going to have to call the bank. There's no one catch-all phrase. Would you agree with that? Yeah, you're going to have to call the bank. Next thing, beneficiary designated accounts. Here's the big thing here. Folks, you need to make sure, A, you've got beneficiaries, and make sure, B, you've got contingent beneficiaries, okay? I'm sure you think you've got them, but unless you have proof, okay, printed out proof, an email or something showing who the beneficiary is, you do not have proof. And if for some reason there's a computer glitch at your financial advisor's office and they cannot find a beneficiary when you die, that asset is going through probate court. And if that asset is going through probate court and it is a 401k or some other tax-deferred account, you have just cost your family a bunch of money in taxes that they would not have had to pay. Okay? So that's how important this is. Make sure you've got beneficiaries named. I can't tell you, we've settled several estates where the couple came in, one of the couple had passed away. They thought, I know she had a beneficiary named. Turns out they didn't have it on file. It had been lost or misplaced. So that's why we really recommend you have local financial advisors that you can work with and make sure your beneficiaries are done right. I did have a horror story. I was using a financial advisor. He's no longer with us anymore, but I have 5 kids, remember? And I was doing these workshops telling people how important it was to get all your stuff in order, and I called my financial advisor and said, hey, I'm just checking. Just want to make sure my stuff's in order because I'm trying to be an expert on all this stuff. You know, I want to look like I know what I'm talking about. And I said, just want to make sure all 5 kids are beneficiaries. He goes, well, no, you've only got 3 on here. Did you have 2 more kids? I was like, oh my goodness, I was going to disinherit 2 of my kids, right? So it happens to me. My law partner, Lewis Graham, his dad had called and they didn't have his right either. It happens all the time. You have a question back there? Mm-hmm.
Would that work?
So the question is, if you die and you have a will, and your will says everything goes equally to the kids, does that work? Is that the question?
Yes.
Yeah, that should work, right? What do you think? Anything?
I think it depends on who dies first, because a lot of times what we see is that one spouse will leave their property to their children after their spouse. The other spouse will leave their property to their spouse, and then if they have predeceased them, to their children, and they end up having competing wills. And so if one spouse dies first, which is typical, then the other, I think I've lost this mic. Then the other spouse inherits everything.
Maybe move over.
I think it's dead.
Yeah, it's battery.
Okay, I will try to speak loudly. If one spouse dies and leaves everything to the other spouse, the surviving spouse's will is going to be the one that leaves it to the children. So you want to make sure that both of your wills are identical. That way one spouse is not competing to outlive the other spouse so that their children can receive everything. Yeah. Does that make sense?
Yeah, the only other thing I'll point out on this slide, on life insurance, the biggest estate I ever settled, the man was leaving all of his money to the church. He'd forgotten about a life insurance that was going to his ex-wife. When they got a divorce, he did not want anything going to her, but he had forgotten about the life insurance. So when he died, the church was kind of happy, but the ex-wife was really happy, all right? And so the question always is, did the man's estate plan work? And the answer to that question is, did it go where he wanted it to go? And the answer to that question is no, right? And so, yes, a question back there. So I guess what she's asking, I think that's the question. She's asking, does the will trump things? And that's the moral to the story we're trying to get you all to understand is your will does not trump how you own things. It simply does not. Your will gets trumped by how you own things, okay? So last point, in trust for accounts, generally you would set these up for minor children. I don't know if anybody here has minor children and they've set up these in trust for accounts, but that's a normal tactic people a lot of times use. The problem with in trust for accounts is that's your kid's money, and when they turn 18, if they pass away, if that account doesn't have a beneficiary on it, you've got a probatable asset, so you're going to have to pay me or Cynthia or some other lawyer to get that money somewhere. Okay, so make sure the in trust for accounts have beneficiaries. So, Greg, anything to add on beneficiary designated accounts there?
No, I probably wasn't completely, if I'm repeating this, but I think the whole part about the will trump these designations that you're seeing on your screen with joint and beneficiaries and so forth, those will trump the will. And I think that's the biggest takeaway from this slide.
All right. Yes, ma'am.
What size estate triggers probate?
Oh, great question. You want to handle that, Cynthia?
No, you go ahead.
Okay. Okay. So the question is, what size of estate triggers probate? So I'm going to give you the classic lawyer answer. It depends, right? It depends. No, so here's the thing. $30,000 is generally the cutoff, okay? And so if you have an estate worth less than $30,000 and you have a paid funeral bill and you have a spouse or children, then they can do what they call dispensing with administration, okay? Which means they don't have to go through the full probate. But if you've got real estate, okay, you're going through full probate, no matter the value. If you don't have a spouse or children inheriting, you're going through full probate. And if you have an estate that's worth more than $30,000, you're going through full probate. Or if you don't have a paid funeral bill, you're going through probate, okay? So in Kentucky, $30,000 is the mark, but there's also some other things that go along with that, all right? All right. Go ahead.
Just one last thing on these transfer accounts. You can have a beneficiary on these accounts, and in some cases it's a really good idea to have beneficiaries. There are good tax consequences to that, and sometimes it's not a good idea to have beneficiaries on accounts. Don't take this as a blanket statement that if you can have a beneficiary on an account, that will avoid probate and that's always a good idea. That is something that you need to be talking with your financial advisor, your estate planning attorney, for each individual type of account and each type of beneficiary you have to determine whether that's a good idea or whether it should pass through probate or through a trust or some other instrument. Yes?
So the question is, how do you prove that you have a paid funeral bill? And the proof is just a fax from the funeral home saying that the bill is paid. That's all you need. Mm-hmm. Right, and so if you have set it up before you die, the bill will be paid and they will send you proof. Other question?
I just want to make sure I understand what contingency beneficiary means.
I'm going to let Greg answer that, yeah.
That your primary,
Repeat the question.
the primary, it would go to the primary if they were alive, right? And it would go to the contingency if the primary was dead?
Yes, you're exactly right. So the question was, what's the difference between a primary and a contingent beneficiary, okay? So typically you're going to set up the primary, and that person, as long as they're living, will inherit those funds. So for example, if you had the spouse as the primary beneficiary, if something happens and you pass away, those funds will go to the spouse, right? Often what you're able to do beyond that is designate contingent beneficiaries. So if you and your spouse are on a trip and something happens and you both pass away, then the contingent beneficiaries kick in at that point. So yeah, contingent is the second layer.
Next slide. Oh, we got the slide here. So next slide is what is a will? So a will controls only those things in your name when you die. So hopefully you all got that now. If you've ever played the card game Rook, hopefully you understand the principle of trumping things, right? If everybody's played Rook before. So how you own things trumps a will. And so also a will, if you're using a will to transfer assets to your beneficiaries, the will has to go through what they call probate court. All right? I can't tell you how many times I've had families come in, spouses says, my spouse died, the will leaves everything to me, why do I have to go to court? And the reason is that your will is not valid until you give it to the judge reads it, verifies that it's your last will and testament, verifies that it's a legal document, that these are your wishes and it's binding, okay? And none of that can happen until after you pass away. So all of this happens after you pass away. They give the will to the judge. He makes sure that it's good, okay? And so that's why a will has to go through probate court. Yes, question?
But do you have to have a lawyer represent you when you go to probate, or can you represent yourself?
Boy, that's a hard question. No, I'm kidding. So the question is, do you have to have a lawyer to go through probate court? And the answer to that question obviously is no. The court is built by the people. Our tax dollars, the courtroom is open to the public. You certainly can do these things on your own. I personally do not recommend it because who here does their own surgeries on their bodies, or as opposed to going to the doctor? Does anybody do that at home? I don't know. How does that work out for you? I don't know. So and that's the moral to my way I look at things. I don't try to do things that I'm not educated to do, right? So I just got my roof put on my house. I did not go and do that. I know some of you all can do that, but I hired a roofer, right? I knew it was going to cost money, but I wanted it done right, especially with Hurricane Ian coming down, or Ian. I didn't want rain coming in through the ceiling. So that's anything to add to there, Cindy?
I think in general, whenever you're talking about legal practices in court, there are some cases where absolutely you can do it yourself because it's a very simple, straightforward case. And then sometimes when you're just going to have to hire help because you need somebody who knows what the practice is, what the local practice, what the rules are. You need somebody who understands the rules of the game. So it's helpful if you think that it's probably going to be a little bit more than you can handle, especially if there are family dynamics at play or if there are different pieces of property you don't really understand. It's helpful to get somebody from the start to go in with you because it's a whole lot less expensive and easier on our end to do it right from the beginning than try to clean up what has been done that has been done incorrectly from the beginning. So in general, yes, you can do it, but you will be held to the same standards as we are, and sometimes that can be a little bit difficult.
I just went to a legal seminar last week in Lexington. They talked to us about the $300,000 will. Who here would like to pay $300,000 for a will? Anybody? No, you wouldn't. So this lady tried to save some money and tried to do a will on her own. And by the time, after she passed away, by the time all the lawyer's fees came in because the will was not done right and nothing was done right as a result of her trying to do it on her own, the lawyer's fees were over $300,000 because all of these beneficiaries fought and fought and fought. And so do not do your $300,000 will, okay? So that's the moral to the story.
And just to be clear, Ben and I do not want that for you. So we do not want to be charging your estate exorbitant sums of money. We want you to do it in the least painful, least expensive way possible because that is going to help you and help your family to do it right on the front end of this rather than, like I said, having to clean it up on the back end. Did somebody have a question in the middle? Yes.
What constitutes a will that is self-proving?
That's a good question. And so the question is, what is a will that's self-proving? So I worked with John Scott for several years when I first started practicing law. John Scott used the old style will, which was proven by two witnesses, and it did not have a notarized statement on the end. And basically, a self-proving will adds an extra paragraph to below the witnesses that verifies that that the person that wrote the will was over 18 and of sound mind. The witnesses were in the room, they were over 18, everybody did it appropriately, all of the stuff was done right, okay? And so our self-proving provision is like a page long, okay? But it can be done in a paragraph. But it's extra verification that everything was done right, and when you pass away, nobody has to go find the lawyer. Okay, so if your will is self-proving, you don't have to go find the lawyer or the witnesses because the will proves itself by the way that it was done. Does that make sense? Okay. So if you have a will and it just has 2 witnesses on it, it does not have a notary on it, you do not have a self-proving will, and when you die, your family's going to have to go find your witnesses or your lawyer. Okay?
What do you do with that when the witnesses went to the bank and got it signed by the people there? And
No.
it doesn't, they no longer put the seal on it.
Right. So the question is, what do you do when your witnesses are at a bank or something like that? If you can, redo your will, in my opinion, so that you can get a self-proving will done so you can avoid all this. Otherwise, there's other ways to prove a will. You can prove it by your handwriting and things like that. Another question? Yes, sir.
Yeah. If somebody gets the will and all the documents done in Kentucky,
Mhm.
and then they try to relocate to another state, they have to get it updated in the new state.
Yeah. And so I'm going to let Cynthia answer this as well as myself. So I practice using the Lawyers with Purpose practice system. And so we just did an irrevocable trust for somebody this week. She lives here in Elizabethtown. She's getting ready to move to Michigan. All right, so we contacted the Michigan lawyer, said, hey, take a look at our stuff, make sure there's not a problem. He looked at it and he said, yep, you're good to go. So and I think Cynthia also uses software, I may be wrong, but because we now use software and use trusts that are used across the country, our documents are going to be pretty much the same across the country, okay? I believe the documents we do here in Kentucky, if you're using this legal software that most lawyers and estate planning use, then they're still going to be good. Now, I still take the extra step of having lawyers in that state look at them before I do the document if I know about a move, or even if my client calls me after we did and say, hey, I'm moving, is this still going to be good? I'll make a contact with the lawyer up there and just make sure. And so that to me saves a lot of time and money. And I will tell you, before I started using this software to do these documents, everything was handcrafted, everything was state specific, and you would have to get your stuff redone if you move. So have it, and yes, I'll get to your question. Let Cynthia answer real quick.
I would echo that for the most part. Because we are part of national organizations, it really does help with continuity across the country to make sure that our documents are going to work wherever you go. But it's always a good idea, whenever you move to another state, to have an attorney who specializes in estate planning to take a look at your document and make sure that it's going to work in the way you still want it to work, because sometimes even though the document itself works fine, there may be tax consequences there that we don't have here. So it's always a good idea to have somebody take another look at that. But in general, yes, the documents that are drafted here in Kentucky are going to work just fine in another state. And some of that is because Ben and I, because this is our specialty, this is what we primarily do, we have somewhat lengthier documents. And so we try to include provisions that are going to maybe not as necessary here, but are going to work really well even if you have to transfer them somewhere else. What was your question?
We've been told that you shouldn't keep your will and important information like trust and all your documents in the safe deposit box at your bank, because if you expire and it's there, there's major issues. What are your recommendations on where to house those?
Yeah, so that's a great question. The question is, where do you keep your estate planning documents? Where's the best place, and is that place a safe deposit box? So when I started practicing law, most people put their stuff in a safe deposit box. That was pretty standard. I'm not going to ask you, but I'm probably the only person my age in this area that has a safe deposit box. For some reason, I've still got a safe deposit box. But there's nothing in there, right? I don't keep anything in there, because if I should die, my family may not know about the safe deposit box, and they're going to have to find the key to get in the safe deposit box, and they may not be authorized to get in the safe deposit box without a court order. So it could be very difficult to get in the safe deposit box And so that is why I personally like to have a special place in your home where you keep all your important papers. You know, your car titles, your deeds, your life insurance policies. That could be a safe in your home if you want, or it could be just like a banker's box in your home, just something like that. Now, I will tell you that I also make available for my clients what they call a client portal online. So if something happens, you and your family can access all of your documents online, regardless of whether you're here in Kentucky or if you're on a trip to Florida. You're going to have your documents no matter what, no matter where you are, okay? And pretty much you can use copies of documents no matter what to get stuff done if something should happen. Anything to add to that?
No, we do the same thing. One thing that we always recommend, though, is if you are going to keep them inside your home, which is preferable, then try to get a fire safe or some kind of firebox. Some people will put them in their gun safe if that's protected. That's fine. Or you can keep it in a fire protected box in your agent's house. That's fine too, as long as you're close to them. Just try to keep it protected if possible. But exactly like Ben said, don't keep them in the safe deposit box of the bank, because it creates a catch-22 where your agent actually can't get to the documents that would give them the right to get to the documents. In the back there.
There are some banks in this town that do not have safe deposit boxes per se. They're like safe deposit boxes, but they're not. Anyone can have a key to go in and have them.
Is that what was the end of that?
Is that okay?
Oh, is that okay?
So the question is, if it's something similar to a safe deposit box at a local bank where you don't have to have an authorized individual, they just have to have a key, would that work? I can't personally speak to that because I don't have any experience with that, Ben.
So the question is, some banks in the county, per your understanding, have something like a safe deposit box where anybody can get in them, and is that okay? I would answer that question, no, that's not okay. I prefer my documents to be somewhere where I know where they're at, and I know who's going to be in there getting them. So that would be the answer to mine. Yes, question?
Some banks have places where you can keep all the original documents in banks. And they also, I think they authorize people, if they work with the estate planning department, for sometimes you guys can keep them.
Yeah. So the question is, I think maybe there's other options about where to keep these things. Our office keeps a copy of every document we sign. Okay. So every document that's ever been signed in my office, we have a copy. We have a digital copy and a hard copy. So if our place burns down, we've got it on the cloud. Okay. Yeah. All right. We'll keep moving along. Probate court. Oh, yes, ma'am. Sorry.
On the previous slide, you had TOD, transfer on death, and paid on TOD. Is one more preferable than the other?
Yeah, so the question is TOD any better or any worse than POD? To me, they're the same. It's the same principle. When you die, whoever is named as a beneficiary on that account, they're going to have to go to that financial institution with a death certificate and prove that you've passed away. And if they can prove that, then they will receive the money that's being held by that financial institution. It used to be that was pretty easy, not a problem. I will tell you that I've had about 3 estates this year where it took like 3 months to get a death certificate. It was obscene. And I think a lot of that is due to COVID. I know you all don't like hearing that word, but COVID has caused death certificates to really be slow, in my opinion. And so it's not always the best thing to do, in my opinion. Also, I've heard that some banks are moving away from PODs and TODs. I don't know the reason for that. I presume some lawyer has sued them for some reason, and they don't want to do that anymore due to liability issues. But I've heard that banks and credit unions are moving away from the POD, TOD accounts.
If your question is which one is better, a POD or a TOD, it depends on the type of account. It's not that one's really preferable to the other. Some accounts are payable on death, some accounts are transfer on death. So it's basically the same principle whether they're going to cash the account out or if they're going to just be transferring the type of account. And Greg may be able to speak to this better, depending on if it's a qualified account.
All right, probate. So probate, you all probably dealt with probate before. Just understand if you own property in more than one state, you're going to have probate in every state where you have property. So, you know, we're dealing with a couple of states right now where there's property in Kentucky, but also property in other states like Alabama, Illinois, South Carolina, different things. So there's lawyers here and lawyers there. So just understand that if you're using a will to get your stuff to people and you have property in more than one state, such as a condo or timeshare, things like that, you're going to be causing your family to have to go through probate court twice and hire 2 sets of lawyers. Okay, so you generally want to avoid that. Probate court, it used to last 7 to 9 months. I can tell you that probate lasts a year at least right now. A lot of that is due to the IRS being backlogged and other issues. And so just understand that your family is generally going to have to wait about a year to get through the probate court process. Also understand that all of the control in a probate case is up to the judge, okay? The control is not with your family. Everything has to be approved by the judge, and the judge doesn't approve everything until all the lawyers have said their piece. And I just remind you again about the $300,000 will to see how effective that is, okay? So also everything you have as far as your assets and who you're leaving those things to in probate is public knowledge. So anybody can see what you have, anybody can see who you're giving it to. So if you don't want people to know what you got, and if you don't want people to know who you're leaving it to, you don't need to go through probate court. Okay? A question?
How long do you have to file probate after you go?
So my reading of the law says you have 10 years to go through probate, okay, overall, to start the process, and then you have 2 years from when you start the process to get a probate case done. Now, the judge will generally grant you extensions after that. You want to add to that?
It may be 10 years, but rarely is anybody waiting 10 years to decide that they want to probate somebody's will, because usually people want your stuff. So they're not going to wait 10 years. They're going to go in fairly quickly and get that started.
I just had a case, though. The guy still hadn't probated. His mom's been passed away for 8 years. He hadn't done anything. And he's got siblings. It's like, oh my goodness, we don't need that to happen, right? So it does happen. Yeah, you had a question?
I don't understand why everyone has a need or the right to see your will. My understanding, they go to the courthouse and
Yeah.
I can see your will, you can see mine. I have no idea, A, why that should be right. And B, if you have a trust, can you set your trust up and no one be able to see that except the persons that receive the trust?
Right, so the question is, why can everybody see your will after you die? And the second question is, if you use a trust, can you avoid the public information of the will? And so the answer to that question, a will is public knowledge because it's a public document, because it's in the court system, right? The court has to approve it. Everything in the court system you can view, because this is the government. You're able to view anything in the government. Now, a court could seal a document. You could ask the court to seal your will, but it won't be likely that would occur. As far as trust are not public record unless for some reason they're recorded. I've never recorded a trust. I don't see any reason to record a trust. So if you use a trust, you're avoiding the public information. So.
One other reason why a will would have to be public is because the creditors have the right to actually file claims against whatever your estate has. So most of us are thinking, well, we probably won't have any creditors at that time, but most people will have some kind of creditor claim if those bills don't get paid. So you may have an illness that leaves some kind of medical bills and they need to file a claim against your estate. They've got to know that that estate has been opened, who potentially the beneficiaries are, and what the estate, they may want to see what the estate actually holds to decide if they even think it's worth filing a claim on.
Anything, Greg? All right. So probate, we always like to tell people, this slide says 5 to 20% AARP. And so it's kind of misleading because the bigger the estate, it'll be the smaller number. And then the smaller the estate will be the larger number. So if you only had we had a case where the man left a $100 fishing boat, John boat, in the backyard. $100. And he had not titled that jointly with his spouse. Guess how much the filing fees were, just the filing fees to get that process. The filing fees were almost as much as the boat, right? And then if you add on a lawyer's fee on top of that, that's why you get close to 20% on these numbers. But anyways, I don't charge 5%. I don't think Cynthia does either. When the first time I ever showed this slide to the public, my mother was there and she said, Ben, why would you tell people how much you charge? I said, Mom, I don't charge this much. But I put the slide up here for you all to understand that a lot of people say, you'll go to a lawyer and he'll say, oh, let's do a will because it's cheap, right? Even though you may need something more. But the understanding is the lawyer then is going to get a big probate fee. Okay, so that's kind of how it works. And so we generally like to help you avoid those costs. Like Cynthia said earlier, we want to help you try to avoid that and get more money to your family so that you're not paying people to go through the probate court process. Anything to add?
If you do have property in other states, some states have probate fees and they have probate taxes and they have very extensive systems in place that take a lot more of your money than we have here in Kentucky. So just keep in mind that if you do move to another state or if you own property in another state, there could be a significantly higher probate cost there than here.
All right, moving right along. How much time do we have?
It's 5 till 11,
How long are we going to?
till noon.
Okay, all right. Yes, sir. No, you only get one. I'm kidding. Go ahead. Okay, so the question is, are you saying you give it to him during your life or after you pass away? Okay, so the question is, and are you presuming you die in Kentucky? Okay, so the question is, if you die in Kentucky and you leave things to your children, what are the inheritance taxes? And per my understanding, there would be no inheritance taxes to leaving money to children, to grandchildren, to your spouse, to your siblings, anybody in that circle. They call those Class A beneficiaries in Kentucky. All right, so that's state rules. However, there are federal inheritance taxes that you do need to worry about. I don't know if we've got them in this slide, but right now you would have to, if you have $12 million and you or more, then you may have some federal tax issues. But as far as Kentucky inheritance tax, just giving assets to your kids, there would not be inheritance taxes on that gift. Does that make sense? Okay. All right. Well, if you give it to a child in Kentucky, yeah, that's right. Yeah. Yeah, so it's a good question. The question is a trust or I presume a will better if you want to do multi-generational planning? I would tell you, I'm going to let Cynthia answer this as well. I think a trust is the best way to go on that because you're not tying that asset up going through the court system on all those generations. Does that make sense? So if you used a will, you're filing the will, you're setting up these multi-generational trusts, and the court's going to be overseeing that, requiring paperwork to be filed all of those years. So think about all the costs tied up with that. Whereas a trust, you're not in the court system, so in my opinion, it saves you time and money on that. Plus, I think it's easier. So,
now, I would just echo the same thing. If you're trying to do multi-generational planning, you really need to be looking at trust planning, not using a will.
all right, what is a trust? So there's two kinds of trust, and I'm gonna be honest. So the first, I don't know, 10 years of my practice, I didn't do trust. Didn't know how to do trust. I was just your general practicing attorney here in Elizabethtown, Hardin County, Kentucky. They don't teach you about trust very much in law school. I hate to break it to you. And so if you go to a general practicing attorney and say, I need a trust, they're going to probably be like I was the first 10 years of my practice and say, I don't think you need a trust. Why don't we just do a will? But the reason I would say that is I didn't know how to do it, right? Because they're complicated sometimes. And so, but I went and got the extra training. I think one year I spent 60 hours in continuing education. I'm currently in an LLM program. This stuff, you have to go and learn about it. You have to go and get educated. You have to go and actually get trained and know how to do these things to understand what a trust is. So just understand that. That not every practicing attorney knows all about trust. But there's basically two types of trust that we use at our office. There's lots of different kinds of trust, but we're going to focus on two: testamentary trust and living trust. Okay? A testamentary trust is one that's inside a will. Okay, so you put the trust inside the will. A lot of you probably did that when you had kids. You'd say, all of my stuff goes to my kids unless they're under 18. In that case, it goes into a little trust for them, and this is the person I want in charge of my kids' stuff, right? That's called a testamentary trust. A living trust is one that's not inside a will. It's its own document, and you actually create it while you're living. You can put stuff in it while you're living if you want to, preferably, generally. And then after you pass away, it says where you want stuff to go. Okay? So it kind of operates like a will, but the trust does not go through the probate court system. Okay? Y'all understand the difference between testamentary and living trust? Anything to add to that? I know, that's why I had to go get extra training. Oh, the question is, if you have a trust, do you still need a will? And the answer to that question is, in my opinion, a good comprehensive plan, if you get a trust, you'll have the trust, which says where everything goes after you pass away, right? Also, it says what's happening during your lifetime. But you'll also have a will. It says, just in case I forget to put something in my trust, just in case I forgot about this or that, I'm going to have this will, and all the will says is everything goes to my trust. It's called a pour over will. It's very simple. It just says, if I die, everything goes over to my trust.
Yes, one way I look at this is if you have certain assets within the trust, okay? Generally, that can be settled much quicker than going through probate. So obviously probate can take up to 12 months, but anything that's inside of the trust will happen at a much quicker pace than anything that goes through the final probate process of the will.
Anything, Cynthia? So on the trust, we do typically revocable and irrevocable trust. Okay, there's other types of trust out there, but we're going to try to keep things, fairly simple. We basically do revocable and irrevocable trust, and we have some slides that will go over those in detail. But essentially, these are in place of the will. Now you're going to have this little pour over will just in case, but these are in place of the will, and this helps you avoid probate court. Okay, so we'll go to the next slide there. Revocable trust. You want to tackle that?
Sure. A revocable trust is one generally that you create during your lifetime. It avoids probate court so that the next person in line who is your trustee, so you name somebody kind of like your power of attorney agent to handle your trust after you either become incapacitated, you don't have the mental ability to do it anymore, or after you die. They can be the same person. Occasionally we'll have different people. But generally, that person, whenever you hit that point that you can't handle it anymore, either because of incapacity or death, they will just step right into that role and they'll be able to continue managing your assets. It's kind of like having a business. Just because the business owner no longer is available doesn't mean that the business has to shut down. The next manager steps into place. So this person is, these trusts can allow for remarriage. They can allow for trust for the kids. These are very comprehensive documents. They can have a lot of different types of provisions and planning based upon what your concerns are. They may have where your trust splits and it protects for blended families while still protecting for the spouse. They may have provisions that take care of minor children until a certain age. Sometimes we will even write very creative and comprehensive provisions for beneficiaries who have addictions, maybe who are just poor money managers, because all of these are there to protect the people that you care about the most in the way that's going to maintain privacy for them, because it doesn't go through court.
Yeah, very good job, Cynthia. And so I like to tell people, you can put anything you want into the revocable trust. The only thing you really can't put in there is any sort of tax deferred account like an IRA or anything like that. So I've got a revocable living trust, okay? I also have an irrevocable trust. So in my revocable living trust, I put my cars. I also put my checking accounts in my revocable trust, okay? And I did that because in a revocable trust, I can put whatever I want into the name of the trust and I can pull whatever I want out of the trust. So if I want to sell my car and buy a new car, I can do it. Put it all in the trust, it stays in the trust. If I want to go to McDonald's and buy a Big Mac this afternoon, I can do that, right? And I'm using that with money from my trust. I'm still in charge of the trust. I'm the trustee. My wife and I, it's a joint trust, and so it's set up with remarriage protection so that when I pass away, if she gets remarried, then this new guy who I won't get all the stuff. And it also sets up trust for my kids, my 5 kids. I'm going to make sure that they're 90 years old before they get anything, But all those things you could put inside a trust, revocable trust. Yes, ma'am, question?
What did you say cannot go in a revocable?
So,
IRA?
right, so IRA, 401k, Roth IRA, things like that, things that are what they call tax deferred accounts, you can generally not put into the name of a trust, okay? And because if you did, you would lose the tax benefits. You would have to liquidate the account. Okay, next slide. All right, so remember the main benefit of the revocable trust is it avoids probate court, makes things easier for your family after you pass away. The next slide talks about irrevocable trust. Irrevocable trusts are used, in my opinion, to protect assets from nursing homes and lawsuits, okay? Nursing homes and lawsuits, that's the primary purpose for using an irrevocable trust, okay? So if you want to protect your assets from nursing homes or lawsuits, then the irrevocable trust is generally going to be the best option for you and your family, okay? And so the irrevocable trust, I generally like to tell people, start thinking about it when you're 70. However, I will tell you also that I'm 44, about to be 45 in January. My wife and I have an irrevocable trust. You may say, Ben, you're in good health. I just ran a half marathon on Saturday. I did great. I don't think I'm going in the nursing home in the next 5 years. However, I will tell you that my wife's father got dementia or Alzheimer's, I think when he was 55, okay? So think about that. In 10 years, I could have a spouse, if she has the same gene pool as her father, that's in a nursing home. And if that's true, then half of our estate could be tied up paying nursing home bills unless I pre-planned. Okay? Well, if y'all remember the story about my grandmother was in a nursing home for 12 years. Think about me being in a nursing home for 12 years and my wife having to pay for everything and paying the nursing home and also taking care of 5 kids. We needed to do planning, okay? Regardless of age, because who knows when these things will happen, okay? So I've got 70 on there, but start thinking about them even if you're 44 like myself. So we do 2 kinds of irrevocable trust, primarily what we're talking about. One of them, you can still pull income out and give it to yourself. Okay, so if you've got a farm or rental property, throw the assets into the name of the trust. You still pull the income out just like you always have, and you're not getting taxed at the trust level. You're still getting taxed at your personal level. All right, and the other kind is you throw the assets in there and you're not pulling the income out to yourself. Okay, these assets again avoid probate, but also get protected from the nursing home and lawsuits.
I just want to remind you of a little disclaimer here. These are 2 of the most common types of trusts that we deal with in this area. There are a lot of different types of trusts. Some of those are revocable, some of those are irrevocable. You may hear special needs trust, retirement trust, charitable remainder trust. All those are different types of trusts, but these are the most common for this subject matter that we're talking about today.
Yeah, and so people always say, why can't I just give my house to my kids, right? Why don't I just give my house to the kids and protect it from the nursing home, all right? So, and the reason is twofold, in my opinion. One, if you give your house to your kids during your lifetime, then let's say they sell it after you pass away because they've got their own stuff, they don't want your house, then they are going to have to pay capital gains taxes on that sale, okay? So if you're like me and you bought your house a long time ago and you don't intend to ever sell it, and that means you got a good deal. So let's say you bought your house for $100,000 and now your house is worth $300,000 and your kids are selling it. Now they're going to have to pay taxes on the $200,000 gain at the rate of about 21%. That's a lot of money that you have burned just by trying to make things easy and simple, okay? That's not smart planning. The second reason is I really did have a case where the parent was going into the hospital for surgery. She said, Ben, I want to do a deed, transfer everything over to my child. She got through the surgery, she came out, and the child did not want to give her house back. That really happened right here in Elizabethtown, Kentucky. And folks, that is scary. That is absolutely scary. You don't want to go through that with your own kids. So do not give your stuff to your kids, in my opinion, just outright, because you lose control and you create tax problems. And those are 2 bad things.
I just had just one other comment on that. I know a family that donated or deeded the farm to the son while they were still living, because obviously they wanted that son to take over the farm after they passed. Well, the son ended up passing away in an accident, and his wife all of a sudden became the owner of that farm. And the parents were still living on it. They were still obviously farming it for income. Well, basically, things didn't go well with their daughter-in-law, and basically she owned the farm and she sold it out underneath them, and they had to move. So this is kind of a big deal when you really get down to it, depending on what you have.
This isn't something that happens a lot, but we have all seen this happen. We've seen, I've had a case as well where somebody deeded their property to their child, and their child thought they were going to be really smart about it and sold the property, leaving a life estate to the parents, which absolutely infuriated them. But something else that can happen is, even if your child has the best of intentions, what if they're in an accident and they get sued? What if they have some kind of liability? This property that they own, they don't live in. They don't have a homestead right to protect this property. And so that property is now at risk for their lawsuit, even though you intended to live in it for the rest of your life.
Yeah.
Wouldn't that also be a concern if you had joint ownership and put them on all of your deeds, like your home deed?
Absolutely.
If they get sued, it would attach your property?
Yeah, the question is, wouldn't these same concerns hold true even if you just added your kid jointly? And the answer is absolutely yes. But here's the issue. So a lot of people over the years in Hardin County, they would go to their general practicing attorney and say, hey, how do I save the house? And they'd say, let's do a pocket deed, or that's where you deed the house to the kid, and the lawyer stores the deed in his top drawer, right? And that's what people did in Hardin County for the last 30 years. And just understand, that is not good planning anymore. That's not best practices anymore. The best practice is not to do that because of the tax and the control issues. Okay? Go ahead.
Should we do a restroom break?
Oh, restroom break. One more question, then we'll do it. Yeah.
I guess I really don't understand the whole thing, but the irrevocable trust, how is that protected from the nursing home? I mean, how do they not come in there and say, well, you have a house, so we're going to get it?
Yeah, so that's a great question. The question is, she doesn't understand, and I'm just kind of, so she's saying, I don't get it. You put the house in an irrevocable trust, and all of a sudden the nursing home can't get it. So understand that anytime you go in the nursing home, that they still do the 5-year look back, right? So if you've done it within the last 5 years, you're still going to have to answer for those things. That's why they always say plant the tree now if you haven't planted it 20 years ago, right? Because you want these clocks ticking, right? So there's some time frame issues when you do irrevocable trust planning that you still have to deal with, okay? But if you do the irrevocable trust, at least, let's just use a general scenario, at least more than 5 years before you go in the nursing home, the entire asset, if the trust is written properly, will be protected from Medicaid, from the nursing home being able to go after it. And the reason, you're asking, what is the reason for that? See, trusts are governed by law. Okay? And the law of this land says that you have to go by the terms of the trust. Okay? So if the nursing home sued you and say, I want to break that trust, the court would get the trust out and read it. And they'd say, oh, this trust says that you can't take the house out and give it to anybody. Is that true? You'd read it and say, yes, that's true. That'd be the end of the discussion right there, because the court has to abide by the terms of the trust, just like you have to abide by the terms of the trust. Okay? And so if the trust says you can't give it out to the nursing home, then the court can't do it either, and the nursing home can't do it either. Okay? So everybody has to go by the terms of the trust. And so you have to do it within proper planning, proper time periods, things like that. But once all that is locked in, then you're protected. Yeah. Yeah. Go ahead. Go ahead. Question?
When you set up trust, do you have to change the names on the deed? Instead of you owning it, does the trust on and cars and things?
Yeah. So the question is, if you do a trust, do you have to retitle everything? The answer to that question is yes, you do need to put new names on it. And that is why at our office, and I think Cynthia's office as well, we assist you with that. We actually have a funding coordinator called Jenny Jones, and she helps you get all the cars transferred, checking accounts, retirement account, everything. She does it all. So it's very minimal effort on your part. You just have to give the okay for it to happen. Yes, question? No, we can't go back. I'm kidding. I'm kidding. Go ahead.
Sell your house even if it's in a trust. I don't understand.
Yeah, so if your house is in a trust and you want to sell it, you still can. So let's say I sell my house to Greg. Okay, I'm going to sell my house to Greg. I give Greg the deed, right? And then Greg's going to give me a check, and that check's going to be in the name of my trust. I can then put that money into my trust checking account, and then I can go out and buy another house, or I can buy a car, or I can buy a CD. I can use that money any way I want to, as long as it's in compliance with the terms of the trust. Okay? That's correct. Yeah. All right, everybody, we're going to get started again. We're on knowing your predators. So look to your left and right, and that person may be your predator to your estate plan. All right, I'm joking, but only half joking, okay? And so the government can always be your predator, unless you work for the government. I'm kidding. But generally, government can be your predator. If you don't have a plan, the government will give you a plan, okay? So if you don't have a will or a trust and you die, the government will give you an estate plan. If you don't have a power of attorney, the government and their rules will tell you who's going to be in charge of your stuff. And I always like to ask this question, who here would like the government to be in charge of all your stuff? Anybody? I've never gotten anybody to raise their hand. Dang it. Okay, all right. So a predator could also be taxes. All of us would like to pay less taxes. And so the government could also, a predator could also be your taxes. Lawsuits can also be a predator. Family members could be predators, okay? Who, your kids or your spouses or things like that, they could also interfere with your estate plan. Of course, nursing home and nursing home care costs would be predators as well. All right, next slide is the text slide. Just going to cover this. We're going to gloss over this because I don't want your eyes to glaze over. We're talking about taxes, but the reason we bring this up is I get a lot of people that come in and say, I'm worried about nursing home protection, and I heard that you can give $15,000 away, and nobody cares about that in the government, and so I want to do that with my family. I want to give all my kids $15,000, and I heard you don't have to count that if you go in a nursing home. And the reason I bring this up is that the tax rules about how much you can give everybody per year have nothing to do with the Medicaid and nursing home rules, okay? They're two totally different rules. So if somebody tells you, I heard you can give away $15,000 or $16,000 away per year and it doesn't count if you go in a nursing home, just tell them that's not true because it's a whole different rule that we're talking about when it comes to nursing homes, okay? So I just wanted to paint big picture about these rules is they can get confusing. Tax rules and Medicaid rules, they can kind of cross sometimes and get confusing, and that's why you don't necessarily want to do it by yourself. But like I said before, you can give away, each of you, $12 million each of you before the federal government will step in and tax your estate. Okay? So that's good. But the reason why we bring this up is when I first started practicing law, the federal government used to tax you when you had $400,000. Okay? So it used to be Middle America used to get hit by taxes at the federal government level because our homes in Hardin County, Kentucky are all going up, and so it's very likely we're going to have a $400,000 estate, possibly, okay, when it's all said and done, on the average. And therefore, under the old tax rules, the federal government used to step in and say, we're going to tax you on those things. And therefore, people used to do revocable trust to try to help out on the taxes. Okay? So if you all go home and get on your phone and search Google and say, who needs a trust and why do I need a trust? It's very possible it may say you only need a trust if you have $12 million of tax issues, $12 million of money, and therefore you have tax issues. Understand that that is no longer true, okay? So you can get confused if you go on the internet and search these things by the tax rules and what people used to use trust for, okay? But understand revocable trust help you avoid probate court. They make things simpler, and the irrevocable trusts that we're talking about, as a general rule, are used for asset protection, okay? So if you go online and get in there and search the online systems, they're going to talk about taxes. And most of us do not have $12 million, okay? I don't have $12 million. I've never met anybody that had $12 million. If you do have $12 million, that is awesome, and you need tax planning. But most Americans don't, in Hardin County, we don't need that type of planning. So just understand the difference. Anything to add to that, Cynthia? Okay. All right. So that's my tax issues. The only thing else I will add, I'm going to let Greg speak, is if you're giving money away to people that are not closely related, so not a spouse, not a child, not a grandchild, then that money can be taxed by the state when you die. Okay? So if you have a friend who you live with, you're not married and you're just living with them and you give your stuff to that friend, that will be taxed in Kentucky. If you give assets to a friend next door because they've cared for you, that will be taxed in Kentucky when you die. Okay? Does everybody understand that? When you die, there are taxes if you give it to stuff not closely related. All right, Greg?
Yeah, I only had one comment where the $12 million number, the $11,580,000, that is set to expire in 2026. This is a temporary exemption. We don't know what amount will happen in 2026. All I know is the government always likes to have more money. So my guess is that'll come down at that point.
Yeah, that's a very good point. Most people are saying it's going to be $6.1 million. So if you have $6.1 million, or if you're married, $12.2 million total, that's where you're going to start seeing the taxes. Of course, that is a floating number like Greg said. All right, next, knowing your creditors, family members, a spouse. So here's the deal. If you get married, a second marriage, let's say your spouse dies and you get remarried, and that second spouse has their kids, just understand by the mere act of getting married to that person now is entitled to, under the law, half of your personal property and a third of your real estate in Kentucky. Okay? So if you're thinking about getting remarried after a spouse dies, understand that regardless of what your will says, regardless of how you own your stuff, regardless of whether it's joint or not joint, half of your stuff of personal property and a third of your real estate is going to the new spouse unless you have a prenuptial agreement, okay? So if you decide to get remarried and it's a blended family, get a prenuptial agreement, please. Or if you already got married, get a postnuptial agreement. Those are effective as well, okay? And all we're trying to do there is make sure your kids get your stuff and their kids get their stuff. We want to treat people fair, okay? And if you just say, oh, I trust my spouse, I'm sure that they'll treat my kids fairly, just understand that they will not, okay? All right, you heard it here. You can blame me. You can say, this lawyer down there said you aren't going to treat my kids fairly. I'll take the blame for you, okay? Anything to add to that, Cynthia? Okay. All right.
Do we have a question here?
Oh, question? Yeah.
Okay, just what you just said, if you have a will or a trust and you remarry,
Yeah.
then how do that go with the kids or whatever?
You're going to need to get a prenuptial agreement or a postnuptial agreement, right, to make sure that things are kept separate, okay? And you need to come in and do a new plan together, okay? Yeah.
Now, my husband and I just did a will earlier part of this year.
And I'm sorry, she asked me if there's a remarriage, what do we need to do? And again, it's a prenuptial, postnuptial agreement with a new estate plan. Go ahead.
Okay, when we did the will, his will was done his way, and he said what he wanted. My will was done my way and said what I wanted. Our will is not together like they used to be when you married.
Right.
It's that he has his will, I have my will.
Right. But so she said, we just got our estate plan done. His will said what he wanted. My will said what I wanted. Isn't that good enough? And the answer to that question is no. That's not good enough. It's just not. Because you're now married. And there's a law on the books that says he's entitled to half your stuff. And if you try to disinherit him and not give him half, he can go to court and get his half. Okay?
Okay, but, I mean, like, when we did our will,
Yeah.
we did it, you get this, I mean, we sit down and we
I know.
read the will.
I know.
And the guy that did our will, because we did it on Fort Knox.
Yeah.
And the way that, he asked us every person that could be asked.
Yeah, I understand. She's saying, do I really have to get that prenuptial agreement? And the answer to that question is, yes, you do. Okay?
Well, why? I mean, if you got that will of the trust or whatever, I'm still not understanding because everything
Right.
was put down. This is the way that it goes.
I understand.
If he outlives me, then this is what I get. If I outlive him, this is what we get. If we both die at the same time, this is the
Right.
way that it goes.
So her question is why? Why? Okay, there's two reasons. Okay, the first is when you die, if you die first, it's all going to him, correct?
Right.
He can change his will the day you die.
Okay.
And I've seen it happen.
Okay.
Okay? I've seen it happen. In fact, I had a couple that said, they came in and she said, I know I'm going first, and I know you're going to get remarried the day after I die. And so, I mean, all this stuff happens. And so he can change his will as soon as you die, and so can you, okay? And the old will be gone and void, and that's why the prenuptial agreement locks it in place. It says, we don't care what you do after death. We've got an agreement. It's binding. You both signed it, and it's good as gold. Okay? Anything, Dan?
All right.
All right. And so that's the thing. You got to do these things right, and you got to do them the way they're supposed to be done. But unfortunately, she went to a lawyer, a great lawyer, but he didn't do the prenuptial agreement. Right? Right?
I'm going back to read it again.
But you know what? If I did your estate plan 10 years ago, I wouldn't have done the prenuptial agreement either. I just wouldn't, because I didn't do this stuff specifically all the time, only this stuff all the time. Does that make sense? So once you deal with somebody that does this and only this, they're going to know you need a prenuptial agreement, because otherwise something's going to hit the fan and it's not good, okay? All right. So last thing on this slide, and I know we got to get going. Cynthia did a great presentation. I'll try to get us going here. Last thing is, if your kids inherit your stuff and then they get a divorce, their ex can take half of what you've left to them. Okay? So if you're leaving everything outright to your kids and then they get a divorce, that ex-in-law can take half the stuff at a divorce. All right? So how do you avoid that? Leave your stuff in a trust for them. Make them the trustee of that trust with a co-trustee of their choice. They can pull it out as they want. It protects you and your kids and protects them from lawsuits and divorces. Who here would like to give all their stuff to an ex-in-law down the road? Anybody? I can't get any takers, Greg. Oh, man. All right. Cynthia, let's move on. The last thing I will just say is nursing home cost. How do you avoid that? How do you protect those assets? Cynthia and I both said irrevocable trusts are the way to protect those assets. All right? All right. Go ahead.
If you set up an irrevocable trust, is there a cost to maintain that down the road, or is it a one and done deal, like you go and write a check and have a will made out?
Right. So the question is, if you do one of these trusts, is it a one and done cost, or there are costs to maintain it, or anything like that? So I get that question every day from people that are doing this, and what we tell people is it's a one and done cost, right? Now, we also offer a maintenance plan for people. Some people want to have meetings with me throughout the year. They don't want to have to pay for meetings all the time. They want to call me all the time. They want me to take them out to dinner twice a year. And for that, we put them on the maintenance plan, all right? And we charge them a small fee, but for that, if there's a change in the law, I'm calling you. I'm saying, hey, Mrs. I don't know your last name, but there's been a change in the law. We need to get you in here right away, okay? And so you're treated as a preferred customer. Does that make sense? Now, but if you don't want to be treated, if you just want to be treated like the rest, there's no cost to maintain these things. It's a one and done deal, and you can change your beneficiaries down the road if you want, things like that. Does that make sense?
There sometimes is an ongoing cost, though, if you're using a professional trustee. Yeah. So that's not an attorney fee. That would be, let's say you have a child who has a mental health issue and you're leaving property in trust for them. You're probably not going to name other children or family members to manage that trust for them. So you may need to name a professional fiduciary, like a trust company. They will have an ongoing charge, but they're also going to continue making money, and they're going to make sure that it's done in the best way possible. So sometimes there are ongoing costs, but as far as setting up the trust, no, there's not going to be an additional cost after that.